Hello, everyone. Oh, another sad day. No bond for Young Thug. It's sad. It's sad. He's been in that jail for all this time. Ah, I digress. I digress. Let me just show you the video of what took place today.
That there are some outstanding bond motions. So Mr. Steele, on behalf of Mr. Williams, has filed a motion for bond reconsideration, but Mr. Steele, you essentially go back and argue anew all of the factors that whichever, I don't even know who took up the bond to begin with, but another court has already considered all of those, the Ayala factors, and you don't present changed circumstances. You just essentially say this call was wrong to begin with and you should do it over. And I am not going to reconsider any bond issues that have already been considered and ruled upon by another court absent legitimate changed circumstances. So that motion is denied.
Wow.
Can I address the court?
Do you have changed circumstances? So, okay, go ahead. There weren't any in your motion.
Mr. Williams has been in custody since the 9th day of May of 2022. This is in my motion. Or it should be in my motion. He has sat through unnecessary jury selection for months, bringing in over 2,000 people when the jurors were chosen from the first 511. That should not be on him. This is excess. He's now sat here for a month while the antics of Judge Glanville and Lawyer Love and Lawyer Hilton cause him to just wander and squalor in a jail. The case is, God forbid there's a conviction, going to be reversed potentially because these are serious issues, and I've raised them. I've put them to the court. There are issues of confrontation clause violations, prosecutorial misconduct, judicial misconduct, not being present at a critical stage of proceedings. There is no reason to believe that Mr. Williams is fleeing. He would be crazy, because if he flees, the case goes on because it's mid-trial and he waives his appellate rights. He has the strongest ties to the community and the backing of wonderful people, both near and far, who are willing to come. Those are my changed circumstances.
All right. Thank you. I do not, they are changed circumstances from, yes, things happened after the bond was decided to begin with. I don't know how I would have decided the bond originally. That's not before me. Those are not the kind of changed circumstances that speak to the Ayala factors, and so I'm not going to reconsider the bond.
Well, let me ask one more then. There is a judge who joined the prosecution team. He said, we need a witness's testimony. He encouraged the witness, more than encouraged, to testify against Mr. Williams. I think that should come anew to the
All
court.
right, well, that may or may not be a substantive error in these trial proceedings. I've got that under advisement right now, but that also would not be an Ayala type change circumstance. Okay. So I appreciate you presenting this to me, but I'm not going to reconsider bond.
Even though potentially it was not done by a fair tribunal.
I don't, so, all right. There is nothing, and I'll make a determination with regard to that substantively, but I will note that Judge Krause, who had a lot of these issues before her in the motion to recuse, her finding while I think dicta, was that there was nothing improper. She said, maybe I'd have done it differently, but that there was nothing improper substantively with what occurred. So at this point, we don't have, and the basis of her recusal was not that Judge Glanville is biased. It was that he engaged too vociferously in setting forth facts and information when he denied the motion to recuse, and that was not what the rules require, and so recusal was necessary. But she even, I think, went on to say, but even with that, I think he could have continued on unbiased. It's dicta, but right now, that is your position in the litigation. It's not a factual finding. It's substantively before me. And if that is the case, then there will be a different ruling made that will impact this trial, that may result in a mistrial, that may result in a mistrial with prejudice, but that would not impact a reconsideration of bond. Now, if there's a mistrial without prejudice, then bond maybe could be considered then. That might be a changed circumstance, but right now we don't have that.
Then I'd like you to address just one last thing then. Judge and district attorneys come out after the ex parte hearing, and not a syllable about Brady evidence. It all should have been spilled right then. That's an ongoing concern. So my point is, you have the same judge denying bond, same judge hiding Brady evidence. So I'd like you to consider that.
All right, thank you. I understand. It's not an appropriate consideration, but I understand what you mean.
Wow. 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 That's all I have today, y'all. I'm as shocked as some of you. I just knew that he was going to get bond. I just knew it. Wow. Okay, see you next time.